Good evening, gentlemen. I'm sure we all had quite a wonderful and great day. All right, you're welcome to tonight's online session. I'm still your host, O.O. Stevens, and we are going to be looking at the topic trial preparation and evidence. Trial preparation and evidence in civil litigation. Now, preparation for trial involves many factors. Preparation for trials involves many factors, and we are going to be looking at the following. 1. Identification of the issues. 2. Formulation of a case theory. 3. Drawing a trial plan. 4. Identifying the burden and standard of proof. 5. Identifying and collating the relevant evidence, and also deciding how the evidence is to be brought or presented before the court. Now, what is case analysis? What do you mean when we say that a case is being analyzed? This has to do with analyzing the facts and laws relating to a case for the evaluation of the weakness and strength of such a case. So it is during case analysis that you are going to look at the facts that have been presented to you by your client to really know whether this type of matter is really a type that qualifies to go to court in the first place, and if it goes to court, whether it's a type that can really have the likelihood of success. For instance, your client may be a renowned prostitute, and she now came to complain to you that a client that paid her for sexual services raped her. So that the client that paid her for sexual services raped her. We know very, very well that in rape, that element of consent must actually be missing before we say there is rape. And we now say that that consent must not necessarily be a type that was not given ab initio. The consent could probably be given ab initio and in the long run withdrawn. And when it is withdrawn, it means rape. But we are now looking at the fact that, okay, you are into this business. You have been doing it. People know you and this is what you are doing. Now a client came and you and the client went into the room, and in the long run you withdrew consent. You told the client that you're no longer interested, that he should come down, and the client refused. So you now capitalize on the fact that you know that absence of the element of consent would make it rape, and you now come to complain. Now the lawyer will now be analyzing the facts that you have presented before him, despite indeed that you denied consent or you retrieved consent. But is this a type that has a likelihood of seeing the light of the day when it comes to court? Because the court will be presented with the fact that this is what this person has been doing, so that she denied consent in the long run, and when the thing had already started is different from maybe she came and complained that she was going home in the night and she was ambushed by some group of men and they raped her. So the circumstances are different. So assuming now is the issue of maybe she was going home and she was ambushed, such one has a likelihood of scaling through in court than the type that she's now presenting, that a man, somebody that came and paid her for social services, they went inside in the long run, she withdrew consent. Such doesn't have a likelihood of flying. So it is at the stage of analyzing the case that the lawyer would now look at the facts that have been presented before him to know the strengths and likely weaknesses that may be inherent from such a case. Now, what about case theory? Case theory, this is the line of argument which, if accepted by the court, will lead to judgment being given in your favor. Now, the acceptance of a theory of a case is determined by the evidence in support of that theory from commencement of the action to when judgment is delivered. In other words, everything done or everything to be done in the course of the trial is limited to the line of argument. So assuming now that you have been given the facts of the case, now after analyzing the case, you will now say that this is the legal name of this particular crime is called rape, R-A-P-E. So that means you have already formed a case theory. So the opinion that you form about a case is known as your case theory. And everything you're going to be doing in the course of the trial of that matter will be regulated by the theory of the case that you have formed. So you are not going to be establishing the element of murder when the theory that you have formed about the case is rape. I'm not going to be establishing the element of rape when the theory that you have formed about the case is what? Murder. So it is when you have already, after analyzing the case, you will now have a case theory. Then from your case theory, now everything that happens in the course of trial is now known. Sorry, everything that happens in the course of the trial will now be regulated by the theory that you have already formed about the case. And now we have trial plan. Trial plan now are the line of argument you are going to take in order for you to win your case. And in trial plan, you are also planning both for your success and also planning planning also for the failure of the other party. So you'll be planning on how to also attack any likely defenses that could be raised by the other party. So in other words, you are preparing both for your own case and also preparing for the case of the other person. So trial plan is the plan, maybe the evidence that you want to adduce, the section of the law that you want to cite, the documents that you want to present during trial. All of them are known as trial plans. So your trial plan is now going to be confined to your case theory. Your trial plan is now going to be confined to your case theory. Now, what about the concept of burden of proof? This is a question of who has the responsibility of proving some facts in a case. And we have two main burdens of proof. We have the general burden and we have the evidential burden. The general burden is the one that does not shift. So the general burden is determined by the state of pleadings or applicable presumptions. So it rests on the party that substantially asserts the affirmative in the case, and it does not shift. So one thing about a civil matter is that the burden of proof must not necessarily be on the claimant. So the general burden of proof must not necessarily be on the claimant. It can in sometimes be on the defendant. For instance, now if there are some presumptions, that are inherent in that particular matter, for instance, now there is what we call presumption of regularity. Maybe that a document is actually presumed to be regular on its face, and it's a rebuttable presumption. So it's left for the other person now to rebut it. Or if probably the defendant has a particular defense to raise in the course of the trial, then the general burden is on him to now probably maybe defend himself by proving the facts that are going to now be in alignment with the evidence that he is adducing before the court. So general burden of proof does not shift, but evidential burden of proof shifts. Evidential burden of proof is maybe when each of the parties want to adduce evidence during the trial, then there will be a responsibility on that particular party that wants to adduce evidence to prove the evidence or to establish the evidence. So that is why evidential burden, we say that it shifts. So it can shift from one party to the other, but general burden does not shift in itself. Now, what about standard of proof? Standard of proof in civil matters is on the balance of probability or preponderance of evidence. Unlike criminal matters, the balance of proof is beyond reasonable doubt. But in civil matters is on the balance of probability or preponderance of evidence. What this means is that in a civil matter, there can still be likelihood of doubt. There can still be what? Likelihood of doubt. But the doubt is no longer weighing much. The doubt is no longer weighing much, or because if the court is now maybe weighing the argument of the parties on that imaginary scale, now there can still be a likelihood of doubt on the part of one of the parties, but the doubt on that particular part is already light. The doubt on that particular part is light, unlike the doubt on the other part that is heavy. So judgment will be given in favor of the person whose doubt is already light. Unlike criminal matters that you must make sure that there is no doubt. If there is any likelihood of doubt that are being traced in the mind of the court, then judgment will unavoidably be given in favor of the accused. But in civil matters, there can still be doubt. But let's say that the doubt in this side is 51% and the doubt in this side is 49%. So the court will likely give judgment on the part that the doubt is 49% and will not give judgment for the other party. All right, let us look at the concept of examination of witnesses. And we're going to be taking examination in chief. It is worthy of note that examination in chief has now been reduced to the adoption of witness statement on oath. So the way you normally have, can you tell this honorable court your name? The way you lead the witness to adopt his witness statement on oath, you have something like, can you tell this honorable court your name? He will say his name, his occupation, and where he's from. Now you ask him something like, have you been to this honorable court before? He will definitely say yes. You ask him, what did you come to do? he will tell you that he came to swear to his witness statement on oath. You will ask him if he sees the witness statement on oath, will he still recognize it? He will tell you yes. And you will now tell him how will he recognize it. He probably say by his signature. Then you will show him the witness statement on oath. Then when he finally says it is it, you still further go, sorry, you still take it further by asking him, what do you want this honorable court to do with this witness statement on oath? Then he will now tell you that he wants the court to adopt it as his oral testimony. So that is how examination in chief in civil matters are being conducted. For instance, law school may require of you to just in a numbered paragraph lead a witness to adopt his witness statement on oath. So you have something like, just don't bother, just only give the questions. It's not your job to talk about the answer. Just give only the question. So you can have paragraph 1, tell this honorable court your name, your address, and your occupation. You have number 2, have you been to this honorable court before? You have number 3, what did you come to do? You have number 4, if you see this witness went on oath, how will you recognize it? And you have number 5, what do you want this honorable court to do with it? So this is the numbered paragraph of how to lead a witness to adopt his witness statement on oath. Now, examination in chief now is often conducted by the party that brought the witness to court. And note that leading questions are not allowed in examination in chief except under any of the following circumstances. Leading questions are questions that the answers are suggested in them. For instance, if you ask your witness now, you were at your house when they came on the 24th day of February, right? Then he will tell you, yeah, that is leading question. As different from asking him, where were you on the 24th day of February? You see that there are two different things. So, but when you tell him you were at your house when they came to rob you, that is a leading question. But if you ask, where were you on the 24th day of February, is a different thing. So these are maybe two different questions that are calculated to get the same answer. So when you ask the one that the answer is already suggestive in it, is a leading question, and it is not allowed in examination in chief. However, it can be allowed if it is with respect to introductory matters. You could have something like, you are Dr. Williams, right? Such is allowed, is introductory matters, except that the name of that doctor is in contention. You can even go further to even talk about his qualification, but most often than not, is not allowed because the qualification can actually be, most often than not, when an expert is a witness, the other party normally loves to tackle or to discredit him from his qualification. So you don't raise anything by qualification. You can just say you are Dr. Williams and stop there. Not saying that you have 16 years experience in autopsy or you have 14 years experience in forensic analysis. So such is not actually allowed. Even if it is introductory matters, just ask introductory matters that are innocent in themselves and are also not a type that has a likelihood of being objected by the other party. So you can ask leading questions on that. Now you can also ask leading questions with respect to undisputed matters. So matters that are not disputed, matters that are not being objected by the other party, you can ask introductory questions. So you can ask leading questions. You can also ask leading questions when a party or when when a witness has been declared hostile. When a witness has been declared hostile is when a witness shows a tendency or an intention of not wanting to tell the court the truth. Please, it is to say the truth, not to say what will benefit the party that brought him to court. There are two different things. So when a witness shows an animus, that is an intention of not wanting to say the truth about what happens, then the other party can apply to, so the party that brought him to court can now apply to the court for such a witness to be declared hostile. Please, it is not the party that brought him to court that will declare him, it is the court. So meaning that there is a requirement for the leave of the court before a witness can be treated as hostile. And treating a witness hostile is to the effect that you can now cross-examine him. You can now use a language like, I put it to you that you are a liar. You can use such a language despite it's during examination in chief. But if the court has not actually permitted you, or if the court has not actually declared such a witness hostile, then you don't use such a language. Now, some of the questions that you can ask during examination in chief, you can ask open questions. Open questions are questions that commence with where were you, why did you do that, who was that, how did it happen, when did it take place. So questions commencing with where, why, who, how, and when, those are known as open questions. So these are questions that normally give the witness the unfettered liberty to explain to the court how everything that happens, because the purpose of examination in chief is to elicit testimony or evidence that will be beneficial to the party conducting such an examination. You can also ask closed questions in examination in chief. You can also ask closed questions are questions that have yes or no as its answer. You can ask such a question. You can also ask incremental questions. Incremental questions like maybe a witness say something like, when he came to my house. The essence of incremental question is just to create effect in the mind of the court. Maybe a witness was testifying, when he came to my house, he shot my dad. After shooting my dad, he gagged my mom. Then he used tape and closed the mouth of my mom. And in the presence of my mom, he tore my pants, or he pulled my clothes and raped me. Now you can ask that same witness. After saying that, you can ask that same witness, did you say he shot your mom? After shooting your mom, he shot your dad. After shooting your dad, he covered the mouth of your mom, and your mom was watching when he did this. Because you can say that in the presence of my mom, he raped me. Then you now say, before the eyes of your mom, he raped you. So you can repeat that thing that witness has said, so that you can create effect in the mind of the court. That is called incremental question. That is called incremental. So it is used to give effect to an earlier answer. You also have transitional question. Transitional questions are questions that commence with something like, can you cast your mind back to what happened on so day? If you see any question that says with something like, can you cast your mind back to what happened on so day, such a question is known as transitional question. But most often than not, if you sit in the examination and law school ask you what type of question is that, just tell them it's open question. Just tell them it's open question, but it is called transitional question in practice. But if you sit in the examination, tell law school that it is open. Safely say it's open question. All right, let us look at cross-examination. This is often conducted by the adverse party. So after examination in chief, the other party will now come to examine that witness. So it is often conducted by the other party. And the purpose of cross-examination is, 1, to weaken the testimony of the witness. 2, to destroy or contradict the testimony of such a witness. 3, to test the veracity, accuracy, or credibility of such a witness. And if such a witness is expert, number 4, then to cast doubt on his qualification. I said it earlier that where a witness is an expert, you normally focus on his qualification to discredit him. So you will want to maybe puncture some holes in his qualification that would normally make the court to maybe not want to believe anything that such an expert would say. All right, we have techniques in cross-examination. We have confrontation technique. We have probing technique. When you are probing such a witness, when you are now digging deep, as the witness is answering your question, you are going further. That is probing. We have insinuation. Insinuation is something like a witness may finish talking. Now you say, okay, can I be correct if I say that you are her boyfriend? You are her boyfriend. If you say something like, can I be correct if you say so, meaning you are insinuating for that witness to now reaffirm, is a technique. You can also have incremental question technique. So that incremental question we talked about can also be a technique during cross-examination. All right, we now have the type of questions that are not allowed in cross-examination, because in a scenario you could see where a counsel will say that he is the cross-examiner and the sky is his limit, meaning that he can ask any type of question. And law school may now come and tell you to comment on that particular statement made by the counsel that the sky is his limit. He can ask any type of question. What law school expects you to do there is to tell them the type of questions that cannot be allowed. So meaning that the sky is not his limit. So there are some questions that are disallowed during cross-examination. One of the questions is indecent and scandalous question. The number 2 is questions calculated to insult or annoy. Number 3 are irrelevant questions and also embarrassing questions. These are questions that are disallowed during cross-examination. Thus, the sky is not the limit of the cross-examiner. Now, what about re-examination? This is the examination of a witness by his own counsel after he has been cross-examined. Now, re-examination is not compulsory except where some ambiguities arose from during cross-examination. So the purpose of a re-examination is to correct those ambiguities. For instance, now somebody may say something like, you said you were in your shop when the accident took place. He will say yes. From your shop, you saw the accident. He will say yes. So he will stop there. He wouldn't want to talk further. Maybe not to, the cross-examiner will stop there. He wouldn't want to take it further, maybe for the court to really understand. So, and as he said, from your shop, you saw you witnessed the accident. He said yes. So the court will now be maybe thinking that the shop was indeed far from the accident scene. So the counsel now that brought him to court, that brought the witness to court, is the one that is conducting re-examination now. He may choose to ask him, witness, what is the distance from your shop to the accident scene? He could say something like maybe I don't really know how to actually okay, maybe something like 1 yard or 2 yards or 3 yards from his shop to the accident scene. Then if it's something like that, now the counsel may not necessarily be comfortable with that answer. He may now tell him, okay, can you actually measure the distance between the accident scene and where your shop is from this courtroom? So the witness can probably say, it is from this place I'm standing now to that place you're standing, or from this place I'm standing now to where the judge is. So from there now, the court will now maybe understand the ambiguities now has been cleared, because the distance between where the shop is and where the accident took place, it was probably not far. So it is during re-examination now that all these things are being cleared, so that there will not be doubt being raised in the mind of the court. Now, we also have another concept known as refreshing of memory. Due to the length of time between the transaction and the testimony witness, such a witness may be allowed to refresh his memory at any stage of his examination. So, for instance, now we are all human beings. There are some times that probably the things that we know has already left our mind. So we may be allowed to consult a document to actually maybe refresh our mind. Probably it was a contract and it was penned down in writing. You probably might have forgotten the date. So you may be allowed to look at the document, that is the contract agreement, to find out the date. And probably the person could actually be maybe a medical doctor or a lawyer. Such a lawyer can be allowed to consult his authorities, that is his books of authority. Or such a doctor can be allowed to also consult his treatise, that is his his practice or professional books, to refresh his memory. But one thing about refreshing of memory is that it has to be with the leave of the court. So you could see in a scenario where law school will tell you that in that scenario, and you see a lawyer now telling the witness, okay, read from the book that is in your breast pocket. And you notice that in that scenario, there is no place that particular lawyer had earlier applied to the court for the leave of the court before asking the witness to do that. So law school may now tell you to comment on the statement made by counsel. So now you should know that particular statement is improper, because he ought to have sought for the leave of the court before asking a witness to refresh his memory. So the concept of declaring a witness hostile and the refreshing of memory all fall within the bounds that you must seek the leave of the court. So if you didn't seek the leave of the court, then such would be improper in itself. Now, what about the testimony of children? What about the testimony of children? Before a child under the age of 14 can testify in any proceeding, the following test must be conducted. The following test must be conducted. 1, whether he understands the questions put to him and can give rational answers to those questions. 2, whether he has sufficient intelligence to justify the reception of his evidence. And 3, whether he understands the duty of speaking the truth. So once a child who is below the age of 14 can actually establish this, then he can give what is called unsworn testimony, unsworn evidence or testimony, meaning that he will not be sworn on oath. There is something called sworn on oath. We are still going to explain that. So he will not be sworn on oath. But if that particular child is above the age of 14 but below the age of 18, then he can give sworn testimony. He can give sworn testimony. Now we have a procedure for swearing in a witness, and also a procedure for affirming a witness, because there are some people that their religion does not actually allow for them to swear, so they can just affirm. Affirming means where a witness will say, I affirm to say the truth, the whole truth, and nothing but the truth, and he will stop there. But if it is swearing on oath is where somebody will now raise his hand and they will ask him whether he's a Christian or a Muslim. He will probably say he's a Christian. If he's a Christian, they will bring Bible. If he's a Muslim, they will bring Quran. If he's an atheist, they would bring Iron, the god of iron. So They will bring it. Now, he will now swear. He will first of all call his name. I, O.O. Stephen, do solemnly swear by this Bible that the evidence I shall give before this honorable court shall be the truth, the whole truth, and nothing but the truth. So help me God. Now, when he says that this is swearing in of a witness, but affirming a witness is just where the witness will just say, I, O.O. Stephen, do affirm that the evidence I shall give before this honorable court shall be the truth, the whole truth, and nothing but the truth. So you now notice now that in affirming now, there is in affirmation now, there is nothing like swear by this, and also there is nothing like so help me God in affirmation. So that is one thing you need to know, because this can actually come out in the examination. So just appreciate the languages that you need to use for each of them. Now, we also have competence and compellability of a witness. We have competence and compellability. When we talk about competence is that to the effect that every person, every adult is in law fit and proper to testify, except it can be established that such a person does not understand the questions put to him by reason of extreme old age, by reason of extreme tender age, or by reason of disease of the mind or body, or of any other cause. Now, this is when we say that a witness is competent. But being competent as a witness is not the same thing as being compellable. Compellable now is when the court can actually order you, or when the court can actually require you to appear before it to testify. That is when we talk about compellability. So everybody is a competent witness, but not everybody is a compellable witness. Now let us now look at those that are not compellable witnesses, those that cannot be compelled to testify in civil proceeding. So those that cannot be compelled to testify in civil proceedings are diplomats. Diplomats are like ambassadors, high commissioners. They cannot be compelled. Also, the president, the governor, the deputy, the vice president, or the deputy governor, they are not also compellable. Legal practitioners, with respect to their communication with their client, that is what we call privileged information. Privileged information. So a legal practitioner will not be required by the court to come and divulge a privileged information that he had already had with his clients. Also, a judge or magistrate, with respect to the matters that they handled or their conduct in that capacity. So a matter that has been handled by a judge will not be required by a higher judge for that judge to come and now talk about that matter or the things that took place in the matter. However, there are some instances whereby a magistrate can be compelled in that respect by virtue of a special order of the High Court. You can see section 188 of the Evidence Act. Now, what about subpoena? Now, there are other people that are not also compellable, so you need to know that. So what about subpoena? When we talk about subpoena is a document that is normally used to secure the attendance of a witness in court. But we have subpoena and we have witness summon. Witness summon is only issued by the magistrate court, but subpoena can be issued by the subpoena is only issued by the High Court. Subpoena is only issued by the High Court, but the magistrate court cannot issue subpoena. The magistrate court can issue witness summon, and High Court can also issue witness summon too. So many High Court can issue both witness summon and subpoena, but magistrate court can only issue a witness summon. And we have different types of subpoena. We have subpoena ad testificandum. This is a type of subpoena requiring a person to come and testify before the court. That is subpoena ad testificandum. And we now have subpoena ad duce tecum. Duce tecum is D-U-C-E-S. Then you shift, you now write T-E-C-U-M. This is a type of subpoena requiring someone to come and tender a document before the court. Now, in subpoena duce tecum, it does not necessarily require the presence of the person. So the person can send another person to bring that particular document to the court, and it will in itself still be properly adhered or respected. Now, we also have subpoena ad testificandum duce tecum, meaning that this is a type requiring a witness to come and both testify and also tender documents before the court. So this is the much we're going to take in this topic, trial preparation and evidence in civil litigation. And we have very validly touched the major areas that ought to be known, and assuming anything is coming out examination wise in this angle. By the grace of God, law school wouldn't go outside the purview of this particular discourse. However, we are not really de-emphasizing the need of associative reading for our various residual knowledge. And until I meet you again, please do take care of yourselves and have a pleasant night rest.